Since I prosecuted the first spoofing case a number of years ago, spoofing has become more sophisticated, and the efforts that the government has undertaken to catch spoofing and to enforce the anti-spoofing laws have gotten more sophisticated and more aggressive. So we're seeing spoofing in the equity space. We're seeing cross-market spoofing. We see individuals use things like order splitters, for example, to split large orders into smaller orders to disguise the size of their orders. And other practices, they'll use modifications instead of cancellations, all in an effort to hide their activity from regulators. And at the same time, we are seeing increased enforcement from the Justice Department, my former employer, but also from the CFTC, CME, and increasingly on the equity side as well. CME casts a very wide net when they're looking at potential spoofing activity. And frankly, lately they have gone even further with Rule 575D, trying to go after large orders that aren't canceled. So in many ways, market participants have to be careful whenever they're trading significant size in the market. I think the regulators need to do a couple things. First of all, I think more specific guidance would be helpful to the industry. I think there are a lot of market participants who really aren't sure what the rules are. I think that's important. I also think that the regulators need to use their discretion in a more appropriate way. At times, we've seen lately, for example, my client, Jitesh Thakar, who was charged, he was indicted by the DOJ. That ultimately resulted in dismissal, but I had to go to trial to obtain that result for my client. They have also recently charged some traders with racketeering, which is a statute we usually go after mob bosses and street gang leaders with. It seems to me that an exercise of appropriate discretion and proportionality would be, I think, very helpful on the part of regulators. It would make it so that the industry is able to have an appropriate response. But you also have to have training and make sure that you're keeping track of when and who is attending those trainings, so that when an inquiry does start, you're able to show the regulator that you did train the individual regarding what spoofing is, and you have procedures in place so that you can review strategies to ensure that they're not spoofing. One practice that I find concerning is the government's use of cooperation as a tool to get firms to essentially act as an arm of the government. So we have seen recently an emphasis on cooperation by the CFTC, and that can be, I think, a good thing for firms to look at. Certainly, if you're facing an inquiry from the CFTC, you want to consider cooperation. But very recently, there was a circumstance in which a firm, actually engaged in questioning of its own employees at the behest of the Justice Department. Those employees didn't know that they were part of a law enforcement inquiry. They didn't know that they should be taking the Fifth and getting criminal counsel. They thought that they were being interviewed by their current employer for a different purpose. And I think that is highly questionable. I know there's litigation pending on that issue right now. But what I would just say is that it's something for all market participants to be aware of, that other market participants you're dealing with may in fact be cooperating with the government and acting at their behest. 575D, the CME's rule that essentially wants trading to be orderly, to use their word, I think that distorts the market, because really, markets aren't always orderly. They don't always, the trading doesn't always occur in a certain way. Essentially says that you can't trade aggressively is really what the point is. You can't put a large order out there. To me, that's going beyond the mission of what CME is supposed to do, and essentially dictates how you can trade. Essentially what it's saying is, you should not be trying to sell large quantities at one time, for example. One thing that I would just encourage market participants to do is not just assume that because they've purchased surveillance software, that is essentially going to take care of itself. In other words, that the surveillance software is just something you can tell the regulator about, but you don't have to interface with it or think about it, in the meantime. You have to think very carefully about the settings in that software. You're going to be asked by the regulator of why you chose to set it a certain way. You're going to be asked what your procedures are for dealing with alerts. You need to make sure that your entire compliance team is trained regarding how they're supposed to interface with traders regarding alerts, how they're supposed to document alerts. Otherwise, you potentially are going to be buying yourself a supervision charge.